Good morning.
Good morning,
Good
sir.
morning, sir.
Okay.
Yes, sir.
First of all, let me extend my heartfelt gratitude to the director of this esteemed institution, HRDC, Mysore, Madam Professor Malini, coordinator of this program, which is being held online, Professor Nanjul Swamiji, esteemed participants, invitees, above all, ladies and gentlemen. I am indeed privileged and honored to share few thoughts on the Constitution of India. Perhaps we may have gone through Constitution of India very well. While you are teaching, you might be, taught in different perceptions on the subject matter of the Constitution of India. What is Constitution of India? You know very well, better than me, I believe. I'll be dealing with a few critical thoughts on the Constitution of India as well. I think that would be fine, instead of just be relied on the fundamental rights, directive principles of state policies, the preamble, the relationship between central and state, the powers and functions of legislature, executive, and the judiciary as well. So I'll be restricted to a few thoughts on the subject. Even if you have got some questions in connection to the constitutional checks and balances, you are liberal to ask as many as questions. I'm happy to answer you. This is my nutshell about the today's lecture. Of course, no doubt, when you deal with the Constitution of India, much has been discussed. I think nothing is left out to me. Be it as if, a citizen of India or from other countries. When it comes to the knowledge of Article 21 of the Constitution of India, wherein it talks about the right to life. What is the right to life? How exactly right to life shall also be looked into. It is a question of fact and law as well. Therefore, understanding the right to life is highly primordial, as I believe. It's a primordial right, without which other rights cannot be enjoyable. This is what we have known on the basis of Article 21 that could be read out with other parts of the Constitution of India. When you are understanding Constitution, you know that understanding Constitution is not so simple. It requires a lot of drill. I believe that Constitution of India is not at all a novel, a story, or a drama, which talks about economic, social, and cultural aspects of a human being country like India. And you know that India is known for its Gramya Bharata. As far as 2011 census is concerned, we had 650,000 villages, country like India. That's why it is to be called as Gramya Bharat. What is Bharat? How will you understand Bharat? How will you understand Constitution? What is law? All are actually mixed here while you are dealing with the Constitution of India as such. You know that some people, they read Indian Constitution, they are not at all understanding. Second, they read it, they know how to understand it, but they don't know how to interpret the Constitution of India. Last but not the least, some people, they read it, they know how to understand it, interpret it. When they are sitting at the higher level, look at their sweeping statements or safe corner statements. So these are the major issues and challenges we have in while you are dealing with the Constitution of India as such. Of course, there are so many challenging issues are there within the ambit of the Constitution of India. The problems in connection to women, children, orphans, LGBT sex, internally displaced persons, refugees, all along we have. Though we have had the Constitution of India, problems of human being, especially in India, remained even today. We are celebrating, as many as the national festivals. Azadi Ka Amrit Mahotsav. Last week we celebrated, Constitutional Day on 26th November 2022. I believe in all respects, though we have had very good constitution with you, look at the situations, country like India. We have had more than 7 lakh internally displaced persons. No rehabilitation has been made so far, country like India. We talk many things on constitution checks and balances. India is incredible. I agree with you. India is incredible. Silicon, making, as many as the slogans we have. But when it comes to the knowledge of vulnerable sections of the society, especially women, children, orphans, LGBT issues are remained. So these are the issues that should be addressed as long as you are dealing with the fundamental rights and the directive principles of state policies as well. And some say that directive principles of state policies are nothing but soft laws, which cannot be enforceable before the honorable courts, be it high courts and Supreme Court as well. And what are soft laws? And how will you understand soft laws and hard laws? It is a debatable issue. One should understand it when you are just opening the minds of the policy makers or the constitutional makers. Look at the way in which we had high debates, especially in the light of the Constituent Assembly debates. We had a number of debates when the constitutional debate were actually going on country like India as such. I believe one of the statements given by Leo Tolstoy, he says, one of the first conditions of the happiness is that the link between man and nature shall not be broken. Yes, I agree with you. There is a closest connection between man and nature that should also be looked into. Why I'm sharing here, when you are making some policies at the state and central level, you shall not be an artificial. An artificial life should be condemned, I believe, on the basis of the Chinese philosophy, in which Lao Tse and Confucius philosophy, they're all actually highly expressive with you to understand the human relationship between ourselves. So therefore, something has to be looked upon on the basis of these factors. I must share with you, though we have had as many as queries or issues or problems, there shall be some conflict resolution. Without understanding conflict resolution, it would be virtually impossible to live as human being. Look at before and after 1945. It varies. I mean to say, before the establishment of a United Nations organization and its half-century enactments, something was different. You should understand it. Before 1945, the entire Europe was battlefield. All were actually involved with many issues and crises. Now you have Constitution and UNO as well. You should understand them and lead your life. I think that would be fine, instead of just be relied on earlier history. This is one thing I must share with you. On the other hand, some say that we have come here to, change the constitution. So what kind of constitution you are going to have it? It's a question of fact and law as well. Then what is constitution? You should understand it. How a constitution should be looked upon. I must share with you, constitution is not at all a drama or novel or a storytelling which talks about the human history. We have with us the Constitution of India. It talks about human history as such. You just open the minds of the constitutional makers, you will be known how exactly philosophical foundations are relied on. Look at the jurisprudence itself. In our jurisprudence, what we call it as philosophy of law, principles of law, doctrines about law, and theories of law. It has outspoken on the law and justice. What is law and justice? It's a relevant question, shall also be looked into. We need to have, legal synergy or legal chemistry or scientific approaches when you are just understanding classical values between law and justice. Your law is looking as if, crude oil, whereas justice is a refined oil, less cholesterol. Please understand here the classical relationship between law and justice as well. Though justice is embedded in the concept of the law, justice is defined from different perceptions or concepts. Law is a means to achieve an end. End means justice. We need justice. Why people are knocking the doors of judiciary? They need justice. They are not come here. Which law is supreme? Whether soft law is supreme or hard law is supreme. That is all about your academic work, if rather I would say. So therefore, you have to understand how, in what manner this constitution has been framed. We put as many as efforts when it comes to the knowledge of Constituent Assembly debates are concerned. There were 8 major committees, framed. While we had, some Constituent Assembly debates. Look at the Union Power Committee presided over, Pandit Jawaharlal Nehru. The Union Constitution Committee presided over Pandit Jawaharlal Nehru. Then the Provincial Constitution Committee presided over, Sardar Patel. Drafting Committee presided by Dr. B.R. Ambedkar. Advisory Committee on Fundamental Rights, Minorities and Tribal and Excluded Areas presided by Sardar Patel. Then Fundamental Rights Subcommittee was headed by Kripalani as the chairman of this committee. The Minority Subcommittee was actually presided by Mukherjee as the chairman. Northeast frontier tribal areas and Assam excluded and partially excluded areas, a subcommittee was actually presided by Gopinath Bardoli as the chairman of this committee. So these are the committees constituted with you to frame the entire text, very well. Well, we were just drafting it. We had 395 articles, 8 schedules, and rest of them. Now we have had as many as articles, schedules, parts of the Constitution of India. This is somewhat, a borrowed constitution. Many people, they are expressing is a carbon copy of, the 1935 Act. Then UN Indian and anti-Indian concepts are also there. And, un-Gandhian constitution, some say it's elephant and size constitution. These are the perceptions in connection to the subject matter of the Constitution of India as well. While we were drafting the Constitution of India, we had a international force. In 1945, when the First and Second World War ended all over India. Look at the rest of them, especially in the international scenario. Vincent Churchill, Roosevelt, Stalin, they sat together and decided to have some peaceful relationship between the states themselves. Thanks to United Nations organization in understanding or maintaining interests of peace and security. We need peace. I agree with you. What do you mean by peace? How will you understand peace? Peace, it does not mean it is an absence of war. Peace means presence of justice. That has to be looked into. See, however, you may have gone through some criticisms leveled against to the subject matter of United Nations organization. UNO has done some commendable job with a view to restore or maintain interests of peace and security all over the world as such. Look at the ongoing crisis. It could be immense civil war, civilian civil war, or what shall I say, the Syrian civil war, the ongoing crisis like especially Ukraine, Georgian, Somalian crisis. The unprecedented issues are actually being committed even today, but there is no sound specific legislation which is actually addressing these issues. So therefore, humanizing the law shall also be looked into. Whenever you want to go for making some legislations at the national, regional, and international level, all these legislations should be framed on the basis of humanity. That has to be looked into. I must share with you, it might be on the basis of philosophical foundations. I agree with you. Even then, first of all, we have to understand how, not manner. The law is actually an imperative with you to understand the problems of human being as well. So therefore, one should respect others. That is the dharma you have. See, you have to understand classical relationship between kriya and karma. Kriya for yourself, karma for others. This is very, very important from the point of view of understanding the human relationship as well. So therefore, you have to understand what is dharma, karma. See, karma means one owes duty towards others. Everyone has his own. I'm not living alone. I'm living with my wife. I'm living with my kids. I'm living with my children. Students. I'm living with fellow human beings, colleagues. All in all, I should know how to behave with somebody. This is very, very important. So why I'm sharing, as long as you are dealing with the rights which are guaranteed under Part 3 of the Constitution of India, duties shall not be forgotten. Rights and duties, they should go hand in hand. Sometimes they are kept in abeyance. You should understand it. And some circumstances as well, where there is a right, there is a duty. Where there is a duty, there is a liability. This is our general relations. You should understand this. If X happens, then Y ought to happen. If X commits a crime, he should be prosecuted. This is our human relationship, which shall also be looked into. However, you may have gone through some critical thoughts on the constitutional law of India. Of course, no doubt, you're all actually like-minded or better judge and judge what is right and what is wrong, isn't it? So what is good for me may not be good for you. What is right for me may not be right for you. But there is a room for discussing all these issues. This is very, very important. Therefore, you have to understand what is to be done and what ought not to be done as well. Look at, with you, you have got very good constitution. You have to understand the constitution first of all, read it once again. If you are unable to read it once again, please repeat it. So that would be fine. See, you have to read the Constitution of India very well. Otherwise, it's very difficult to run the show, or it's very difficult to resolve the problems between individuals and the state as well. So therefore, you have to understand the Constitution with the humanitarian perceptions are concerned. Though we have had some critical observations, whether egg is first, hen is first, military necessities first, humanity is first, war is first, species first, or women are first, men are first. See, nobody is a superior, as I believe. All are equally footing. You should understand it. You cannot be stronger by exploiting others. This is what the philosophical foundations have already been outspoken with you to understand the relevancy of the law as well. You have to understand it. First of all, how exactly the Constitution of India should be taught, and how exactly the Constitution is to be defined. And some say that we have come here to change the Constitution. So what kind of Constitution you would like to have it? ಯಾವ ಸಂವಿಧಾನ ಬೇಕು ನಿಮಗೆ? ಅದು ನಮ್ಮ ಪ್ರಶ್ನೆ. ಯಾವ ಸಂವಿಧಾನವನ್ನು ಬದಲಾವಣೆ ಮಾಡ್ಲಿಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ? ಅಥವಾ ಯಾಜ್ಞವಲ್ಕ ಸ್ಮೃತಿ ತರಲಿಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ? ಮನುಸ್ಮೃತಿ ತರಲಿಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ? ಕೌಟಿಲ್ಯ ಅರ್ಥಶಾಸ್ತ್ರ ತರಲಿಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ? ಅಥವಾ ಇನ್ನಿತರೆ ಸ್ಮೃತಿಗಳು, ಶ್ರುತಿಗಳು, ಆ ಒಂದು ಪರ್ಸೆಪ್ಷನ್ ಅಲ್ಲಿ ಅಥವಾ ಚಾಣಕ್ಯಸ್ ನೀತಿ ತರಲಿಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ? ಈ ಯಾವುದು ಕೂಡ ಕ್ಲಿಯರೆನ್ಸ್ ಇಲ್ಲ. ಪೇಪರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡ್ತೀರಾ ಅಷ್ಟೇ. ನಾವು ಬಂದಿರೋದೇ ಸಂವಿಧಾನ ಬದಲಾವಣೆ ಮಾಡ್ಲಿಕ್ಕೆ ಅಂತ. ಯಾವ ಸಂವಿಧಾನ ಮಾಡ್ಲಿಕ್ಕೆ ಹೊರಟಿದ್ದೀರ ಅನ್ನಲಿಕ್ಕೆ ಸ್ಪಷ್ಟತೆ ಇಲ್ಲ. There is no clarity as such. Which constitution you would like to have it? At least you should understand the existing constitution very well. ಇರೋ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅನ್ನ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಕ್ಕೆ ಟೈಮ್ ಇಲ್ಲ. ಬೇರೆ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅನ್ನ ಇನ್ಯಾವ್ ತರ್ಲಿಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ? ಅದಂತೂ ಸತ್ಯಕ್ಕೆ ದೂರವಾಗಿರುವುದನ್ನ ನನ್ನ ಒಂದು ಭಾವನೆ ಅಂತ ನಾನಾದ್ರೂ ಭಾವಿಸ್ತಾ ಇದ್ದೇನೆ. ಸೊ ದಿಸ್ ಇಸ್ ವಾಟ್ ಒನ್ ಶುಡ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ when you are just understanding the constitutional law for India. Of course, Constitution has given you as many as the rights, that are fundamental rights and direct principles of state policies as well, and which talks about the humanity, perceptions, and understanding. All in all, I must share with you, it might be philosophical. I respect your truth. Please respect my truth. That is the strength. I respect your truth. Please respect my truth. That is the strength one should understand. And in a silver linings, I can say that you should know where exactly you have come from. Then only you appreciate yourself. Where are you going? This is very, very important. In nutshell, I can say, if somebody is actually crying at home, that the mother should know why he is crying, why she is crying. In turn, I can say that it is one of the responsibilities on the part of a state should understand the problems of human being, country like India. Otherwise, it's very difficult to understand what is the state responsibility as well. What is state responsibility? How will you understand state responsibility? There is a definition in connection to the state responsibility as stated under draft articles on state responsibility for wrongful acts committed 2001, which was actually drafted by 5 special rapporteurs of International Law Commission, who have actually outspoken on the concept of state responsibility as such. When a state, state violates an international obligation or obligations, when a state violates an international obligation or obligations, then the state responsibility can be fixed, which is in total distinguished with the liability concept as such. You should understand a classical distinction between liability and the responsibility as well. Here, when you are sharing with the concept of state responsibility, which was actually emphasized by 5 special rapporteurs of International Law Commission, you should understand it, how a state is responsible. That's why, with you to understand the crux and balances of these, I have given you an example. Look at, if somebody is actually crying at home, that the mother should know why he is crying. She should understand why he is crying. This is very, very important. If something has gone wrong, take for an example, connects to many things, like especially in Karnataka. There are so many tribes who are living in hill station areas and border areas. They could be Soligas, Yarava, Jenukurba, Bettada Kurba, Kadu Kurba. Then cities, they might be, Muslim city, Christian city, then Hindu city, who or maybe. Though we have had some specific legislations, country like India, they could be in a Forest Dollars Act of 2006, that could also be looked on the basis of Protection of Biodiversity Act of 2002. Even today, they are highly vulnerable, retracted, and marginalized. Though we have had the Constitution of India and the specific legislations which are addressing these issues, no rehabilitation has been made so far. Please visit BR Hills, Bandipur, Nagarvale, Joyda, or Ankola, or somewhere else, country like India. They are all actually highly marginalized sections of the society, and no rehabilitation has been made. We are reaching more than 75 years of experience, country like India. We have known everything about the constitution checks and balances and the developments that are taken place at the international level as well. Look at Declaration on Right to Development 1986, which was highly speculative with a view to understand all in all. Declaration on Right to Development 1986. Later on in 2000, we could find Millennium Developmental Goals at the international level. Same thing was a replica when you could deal with Sustainable Developmental Goals 2015 to 30. You just have a look on Sustainable Developmental Goals 2015 to 30. We have had our own action plan to overcome world hunger and the poverty as well. Even today, though we have had as many as specific legislations in connection to elevation of the poverty and the food security loss, the problems have remained even today. Look at all these issues: food security loss and the elevation of the poverty legislations. Therefore, instead of just be relied on the provisions of the Constitution of India, kindly have a look on critical thoughts on the subject as based on the constitutional morality. Then what is constitutional morality? How will you understand constitutional morality? Where exactly the constitutional morality has come through? What are its roots? Roots are there in natural law, natural rights, human rights, fundamental freedoms. All in all, we have. How will you understand human rights? You know very well, better than me. Human rights are nothing but basic rights, natural rights, inalienable. They are inherent. They are there everywhere. There are no boundaries. You can find human rights in outer space, seabed, subsoil, ocean floor, and Arctic Ocean as well. They are there everywhere. They have no boundaries as far as the human beings are concerned. We are all human beings, no matter. You may have come from little background, that's a different issue, but you are a human being. All human rights should be respected and protected. Look at the UN Charter 1945, wherein it starts with we the people of United Nations determined to save the succeeding generation from the scourge of war, which is untold sorrow, which cannot be explained once again. That First and Second World War, as you have already been known, that entire Europe was a battlefield. There was no scope for protection of human rights and fundamental rights as well. All were actually involved with war crisis. What is war? War is nothing but contest between states. Now, that definition is redundant. You have to redefine it. What is war in these days? War is not only a contest between states, but also individuals. So therefore, law is an imperative with a view to understand classical differentiation between war and peace. What is war and peace? You have to understand it, first of all. Peace, as I've already been made clear, that peace, it does not mean it is an absence of war. Peace means presence of justice. We need justice. We need distributive justice and corrective of justice. Why people are knocking the doors of judiciary? They need justice. I need justice. You need justice. So this is what one should understand. Look at as many as cases decided by Honorable Supreme Court of India. There could be, Sajjan Singh case, Shankari Prasad case, Golaknath's case, Keshavananda Bharati's case, Minerva Mills case, Raj Narayan's case. Then as many as cases like Muslimani's case. There are so many cases have been actually decided by Honorable Supreme Court of India with a view to understand fundamental rights, directive principles of state policies, and the duties of citizens as well. So that's therefore you have to understand when you are dealing with constitution, you have to balance the rightistic and duty bound approaches. As I said, where there is a right, there is a duty. Where there is a duty, there is a liability as such. That's why you have to understand the constitutional checks and balances as well. As you have already been known, this constitution has been in fact dealing with socio-economic and cultural aspects. We have known that there is a serious threat to the Constitution of India in these days. So something has to be looked upon. First of all, I must insist you to read the entire Constitution as such. So in this Constitution, we have had, multicultural and ethnic pluralism as well. You have to understand multiculturalism and ethnic pluralism. So without understanding multiculturalism and ethnic pluralism, whatever you are reading, the Constitution of India would be incomplete and impracticable as well. So therefore, when you are dealing with this Constitution, I must share with you, Constitution means people. People means Constitution as well. You have to understand how people are living over there, especially in India. This is one of the major aspects which shall also be looked into. Look at the ancient system, feudalism, slavery, capitalistic movement, socialistic pattern of society. The unprecedented issues were actually common, quite common. So that you have to overcome. Therefore, you have to understand all in one. It could be on the basis of caste, religion, justice delivery system, economic, social, and political system. Last but not the least, the social values in the situation as such. Here, what I would like to share with you, whatever you have defined, Bharat or Bharata Khanda, that is all about your, let me share with you, that is all about your geographical definition you have. Geographical definition. ಒಂದು ರೀತಿಯಲ್ಲಿ ಏನು ಹೇಳಬೇಕು ಅಂದ್ರೆ ಭೌಗೋಳಿಕ ವ್ಯಾಖ್ಯಾನ ಮಾಡಿದಿ ಭಾರತ ಖಂಡ ಅಂತ. ಏನಂದ್ರೆ ಉತ್ತರದಲ್ಲಿ ಹಿಮಾಲಯ ಪರ್ವತ ಇದೆ, ದಕ್ಷಿಣದಲ್ಲಿ ಹಿಂದೂ ಮಹಾಸಾಗರ ಇದೆ, ಆ ಕಡೆಗೆ ಬೇ ಆಫ್ ಬೆಂಗಾಲ್ ಇದೆ, ಅರೇಬಿಯನ್ ಸಿ ಇದೆ, ನಡುವೆ ವಿಂಧ್ಯ ಪರ್ವತಗಳಿದೆ ಅಂತ ಡೆಫಿನಿಷನ್ ಮಾಡಿದ್ವಿ. That is all about your geographical definition as well. Being a student of law, I can say Constitution means people. People means Constitution. ನೀವು ಯಾವುದೇ ದೇಶಕ್ಕೆ ಹೋಗಿ ಅಮೆರಿಕನ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಓದಿ, ಕೆನಡಿಯನ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಓದಿ, ಸ್ವಿಸ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಓದಿ, ಪಕ್ಕದಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ರಾಷ್ಟ್ರಗಳದ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಓದಿ, ಚೈನೀಸ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಇರ್ಬೋದು, ಜಾಪನೀಸು, ಮ್ಯಾನ್ಮಾರ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್, ದೆನ್ ವಾಟ್ ಶಲ್ ಐ ಸೇ, ಶ್ರೀಲಂಕನ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್, ಎಲ್ಲಾ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ಗಳಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಸಮಸ್ಯೆಗಳು, ಪರ್ಸೆಪ್ಷನ್ಸ್ಗಳು ಒಂದೇ. ಬಿಕಾಸ್ all are human beings. You should understand the concept of the Vasudhaiva Kutumbakam, which talks about the philosophical foundation. We are all actually belonging to single family. This is to be called as a Vasudhaiva Kutumbakam. So the why Vasudhaiva Kutumbakam concept has given you some magnificent approaches on the society. Of course, no doubt, it is relevant from the standpoint to understand what is the Vasudhaiva Kutumbakam as well. So therefore, you have to understand on the basis of these factors. This one thing. On the other hand, as long as you are dealing with the constitutional law of India, so long you shall not be forgotten on the religion as such. What is religion? Religion is nothing but pathway to realize the God. You may be belonging to any religion, we don't mind. You may be belonging to Christianity, Islamic faith, Buddhism, then Hinduism, Parsism, Zoroastrianism, Sikhism, such other religious fundamentalisms we have. What is religion? You have to define it. Religion is nothing but pathway or to realize the God. It is up to you to decide. Kindly have a look on Article 25 of the Constitution of India, wherein it has outspoken on right to freedom of religion. Rights are also there, freedoms are also there when you are enjoying religion, your religion as such. But in recent past, in the name of religion, people are going to be targeted. This is somewhat, highly pathetic issue. And don't be an artificial while you're understanding your own religion as such. Don't blame others' religion. You should understand a Sarva Dharma Samana concept through which you have to understand. Look at Article 14 of the Constitution of India, wherein it has outspoken on right to equality. Like should be treated alike, unlike should not be treated like. Equality before law and equal protection of law, they should go hand in hand. All are equal, but some of them are not equal. Please understand. It is highly classical when it comes to the knowledge of Article 14 of the Constitution of India as such. Look at the protective discrimination. Protective discrimination, or otherwise you can say reservation and quota, which is highly expressive under the Constitution of India, which is in fact derived from the vulnerability. That you should understand it. Look at the American Constitution. In American Constitution, it has outspoken on vulnerable sections of the society as well. Even in America, all are not richer. People have come from little background also. For them, law shall be made available. Look at the affirmative action of the Constitution of India, or sorry, Constitution of America as such. In American Constitution, the affirmative action is well known. Similarly, in the Constitution of India, we have outspoken on reservation and quota. Look at British Constitution, wherein it has outspoken on positive discrimination. Look at the positive discriminations in UK, affirmative action in America, reservation and quota, and the Indian Constitution are one and the same. You have to understand each one of them, especially in the lowest strata. People are highly vulnerable, retracted, and marginalized. For them, law shall be made. Law shall be made. It could be soft law or hard law, whatever you might be finding. That's a different issue. In absence of a hard law, then the soft law will play an important role. Though soft law has been made on the basis of political ideologies, soft law is also playing an important role in some situations are concerned. Therefore, you have to understand all these issues and challenges based on these factors are concerned. So, with these few aspects, rather I would say, look at right to life, which includes a wholesome environment. We need to have very good environment. And you know that only 3% of the water is kind enough for human consumption. What about 97% of the water? It is highly contaminated. So therefore, you have to understand, even from the perspective of the right to life, which is highly expressive under Article 21 of the Constitution of India. Of course, we talk many things on preservation of human environment, which is highly expressive under Article 48 of the Constitution. Right to life, which includes right to wholesome environment. Look at some basic principles which are highly expressive. It could be polluter pays principle, sustainable developmental goals, then common but differentiated responsibility, common heritage of mankind, common concern of humanity, precautionary principle. All in all, we have, along with the continuity of these specific principles, we have optimal utilization of natural resources. You know that earlier what had happened, you had more natural resources, less population. Now you have more population and less natural resources. That's why your Earth planet is going to become smaller and smaller. Your Earth planet is going to become smaller and smaller. So therefore, optimal utilization of natural resources shall also be one of the major concerns on the basis of the constitutional checks and balances. So therefore, of course, no doubt, India is known for its international relations. We took part in many international agenda 21, then sustainable developmental goals 2015 to 30, Rio de Janeiro Declaration, then Stockholm Declaration 1972. All in all, we have. See, what I would like to share with you, however, we may have gone through some critical thoughts on the subject like the Constitution of India. First of all, you have to understand Constitution on the basis of the developments that are taken place at the international level as well. So this is very, very important for the point of view of the understanding the Constitution of India and the public international law as well. You have to balance the Constitution of India and international law as well. What is international law? You can put a fundamental question. International law is nothing but body of rules and principles which regulates members of international community as a whole. So therefore, you have to understand, even from the point of view of Article 51 of the Constitution, wherein it has outspoken on the application of international law. This is actually well known even under Article 253 of the Constitution. It means that the Constitution of India should also be looked on the basis of developments that are taken place at the international level as such. You are also one of the member countries of WTO, that the World Trade Organization and UNCITRAL models. When you have become one of the member countries of these international institutions, you should understand human relationship. Look at, sit for a while in an international airport, Bangalore, how many foreigners are entering India, how many Indians are actually migrating to other parts of the world as such. Unimaginable proportions of human migration is there. You know very well, earlier we couldn't find passport and visa. Now we are finding passport and visa to visit some countries. So therefore, you have to understand all these aspects depending on the human migration as well. Why I'm sharing, especially in India, we have more than 7 lakh internally displaced persons. Perhaps you may have come across with these issues while you were researching in your area as such. Internal displacement is one of the major issues. Who are all internally displaced persons? It's a question of fact and law as well. See, internally displaced persons are not supposed to be crossed, international border. They are within us. Due to some flood, famine, natural calamities, or mega projects issued by the state and central government, people are going to be displaced from one place to another place. This is quite common when it comes to the knowledge of Narmada incidents, Tehri projects, even Etinavale project in the state of Karnataka. say unimaginable proportions of the people are actually migrating to other parts as such. So my observation is very simple. When you have gone through the human migration, obviously it is your duty to rehabilitate them. This is very, very important. Without rehabilitation, don't pull them back to other places are concerned. You have to find out a suitable place to live. It's a question of right to life. You have to understand. All are human beings. You are reading the entire Constitution. I agree with you. You can start with preamble, end with amendments, then schedules, parts. All in all, you are reading. I agree with you. I'm not disputing at all. Still, there is a room for discussing some issues and challenges of human being. None other than internally displaced persons are concerned. At least refugees are well protected. For refugees, there are some international institutions have set up, like UNHCR, United Nations High Commissioner for Refugees. This is one of the specialized agencies of a United Nations organization. What about internally displaced persons? The people who were actually forcible from Nagaravale, Bandipur, BRLs, even today they are unable to access some rights. This is somewhat pathetic. What I would like to share with you, though we have had crossed more than 75 years of experience, the problems are quite common and vulnerable as well. So therefore something has to be looked into, and you cannot say who bells the cat. You have to bell the cat and see where exactly it's moving. Simply you cannot say on the basis of earlier history. You are just going back. Something has to be looked into. ಇವತ್ತಿನ ಕಾಲದಲ್ಲಿ ಏನಾಗಿದೆ, ಸಂವಿಧಾನದಲ್ಲಿ ಏನು ಸಮಸ್ಯೆಗಳಿದಾವೆ, ಅದನ್ನ ಯಾವ ರೀತಿ ಹೋಗ್ಲಾಡಿಸಬೇಕು. ಅಂತಾರಾಷ್ಟ್ರೀಯ ಮಟ್ಟದಲ್ಲಿ ಸಾಕಷ್ಟು ಬೆಳವಣಿಗೆಗಳು ಆಗಿದ್ದಾವೆ. ಯುನೈಟೆಡ್ ನೇಷನ್ಸ್ ಆರ್ಗನೈಸೇಷನ್ ನಲ್ಲಿ ಬೆಳವಣಿಗೆ ಇದೆ. ಅಂತ ಒಂದು ಕಾನೂನುಗಳನ್ನ ನಾವು ಲೋಕಲ್ ಅಲ್ಲಿ ಯಾಕೆ ಅಡಾಪ್ಟ್ ಮಾಡ್ಕೋಬಾರದು? ಇವೆಲ್ಲ ಪ್ರಶ್ನೆಗಳು ಬರುತ್ತೆ. So therefore you have to understand the constitutional checks and balances on the basis of the developments that are taken place at the higher level as such. That's a international level as such. So this is one of the major aspects shall also be looked into. I must share with you, everyone has his own. You should have your own choice. I should have my own choice. That has to be looked upon. Bacteria needs to live. You are killing bacteria for our survival. That's a different issue. Bacteria needs to live, and prostitutes should have a choice. I believe, as a student of law, I can say that even prostitutes should have a choice. This is very, very important from the point of understanding the the Constitution. You just open the minds of the makers of Constitution. All are there, be it women, children, orphans, LGBT, sex. All in all, we have had. You have to understand it first of all. Okay. Otherwise, how will you understand the Constitution of India? Look at one of the statements given by V.R. Krishna. In many instances, what he says, that one of the first conditions of the happiness is to bridge the gap between human and the nature as well. This is what, and in a silver linings, he has exposed to share that access to justice is in fact one of the human rights. This has to be looked upon, and even in otherwise manner, Justice Anand of UNHS, National Human Rights Commission, he opines that poverty that itself is a violation of human rights. Poverty that itself is a violation of human rights. And then access to justice is one among human rights. That has to be looked upon. Otherwise, it's very difficult to have a look on what is to be done and how exactly the Constitution should be looked into. On the other hand, as long as you are dealing with rights, so long as duties shall not be forgotten. So therefore, you have to define what is right. Right, it is an interest recognized and protected by law. Rights are actually from a different perceptions and observations as well. You have to understand what is right and how, in what manner rights shall also be looked into. The synergy is very simple here. That synergy shall also be looked on the basis of seminal significant approaches, especially a country like India. So these are the perceptions one should understand. Even in otherwise manner, there are so many definitions given by various experts in the field of law as such. You just open the jurisprudence, you will have gone through as many as definitions in connection to law, right, duties, and as well. You just open and understand the natural law theory, American realism, Scandinavian realism, economic approaches, then anthropological approach, then synthetic jurisprudence. You will have gone through how exactly a law shall be looked upon, rights should be looked upon, or duties shall be looked upon. Otherwise, it's very difficult to understand what is to be done through the constitutional law for India. Look at the preamble. In the preamble itself, we start with "we the people of we the people of India." This concept is actually derived from American Constitution. You just go through American Constitution, it starts with "we the people." Likewise, Indian Constitution and the preamble of UN Charter 1945. UN Charter 1945 would start with "we the people of United Nations, determined to save the succeeding generation from the scourge of war, which is untold sorrow." So these are the things that shall also be found to be correct. Of course, no doubt, when you are just sharing with the preamble, which talks about philosophies, objectives, intention of its framers, which talks about history behind its creation and the core values, principles of the nation. The preamble basically gives idea of the source of the constitution, nature of Indian state, statement of its objectives, state of its adoption as such. So in this context, first of all, we have to understand what is preamble of the Constitution of India. Perhaps you may have gone through very well while you were teaching the subject as such. Keywords in the preamble, we have had all these like sovereign, socialist, democratic, secular, democratic, republic, all in all we have. The objectives of the Constitution. Have a look on the objectives of the Constitution. The objectives of the Constitution is actually well known. You are dealing with social justice, economic justice, political justice, equality, liberty, fraternity, all in all we have. What is social justice? Especially in a case which has been decided by Honorable High Court of Bombay, the citation is this: Prakash Cotton Mills versus State of Maharashtra. In this particular case, in fact, Justice was Chagla, one who was one of the best friends of Dr. B.R. Ambedkar, who defines the social justice in this way. Without understanding the social justice, a law cannot be interpreted. Social justice is the basis while you are dealing with the Constitution of India as such. When it comes to the knowledge of objectives of the Indian Constitution, all these factors shall also be looked upon and understood. So it could be social justice, economic justice, political justice, equality, liberty, and fraternity also. Even in otherwise manner, Justice V.R. Krishna, who has exposed to share that if you want to have a just society, social justice should be observed. In order to create very good justice society, social justice shall also be underlined. So therefore, you have to understand. Look at the status of preamble through the Birubai case. In this particular case, the court held that the preamble is the key to open the mind of the makers, but it cannot be considered as part of the Constitution. Therefore, it is not enforceable in the court of law. This was one of the aspects and aspects of the preamble of the Constitution. However, it might be preamble is the basis with you to understand all in all. Look at Kesavananda Bharati's case. It says that the preamble of the Constitution will now be considered as part of the Constitution. Earlier instances were different. Now it has become a part of the Constitution. This is what the Kesavananda Bharati's case has already been outspoken. The preamble is not the supreme power or a source of any restriction or prohibition, but it plays an important role in the interpretation of the statutes and provisions of the Constitution. So it can be concluded that the preamble is part of the introductory part of the Constitution as well, which is highly contradictory in connection to Birubai case as such. See, the interpretation of the Supreme Court of India is highly expressive when it comes to the knowledge of the preamble of the Constitution of India. In many cases are concerned, that you have to understand as well. In 1995 case of Union Government versus LIC of India, it says that preamble is the integral part of the Constitution, but it's not directly enforceable in the Code of Justice in India. So time and again, so we have been actually interpreting the very purpose of the preamble of this Constitution as well. It's the lengthiest Constitution of the world, you know very well, which talks about sovereign, socialist, secular, democratic republic as well. Have a look on S.R. Bommai's versus Union of India's case. It was held that in the matters of state, religion has no place, and also said that secularism is one of the basic features of the Constitution. In a silver linings, in the famous case, Indira Nehru, Gandhi, Sri Rajanarayan, and others, it was held that the state will not discriminate against any citizen on the ground of religion as such. You know very well, religion is nothing but pathway to realize the God. You may be belonging to any religion or religious fundamentalisms. So you should understand what is religion as such. So you have to go beyond that. See, your Constitution should not be in an otherwise manner as such. I mean to say, your Bible is not your Constitution. Similarly, your Quran is not the Constitution of India as well. Bhagavad Gita is not the Constitution. Your Constitution is a supreme as well. Constitution is a supreme, suprema lex, and a lex specialis. It is a supreme, which talks about the human history as well. Say, we have framed the Constitution based on earlier history. You should understand it. Though we had some categorical differentiations on the basis of westernization and easternization as well. The westernization has come through on the basis of Christianity, whereas easternization has come through on the basis of the Islamic faith as well. You have to understand the classical distinctions between westernization and the easternization as well while you are dealing with the Constitution of India as such, which is actually dealing with the socialist, especially in the Samatha state of Andhra Pradesh. According to this case, the court held that the term socialist is used to lessen the inequalities in income and status and provide equality of opportunity and facilities as well. As I said, all are not richer. Some of them have come from little background. For them, law shall be made available on the basis of socialistic pattern of the society as such. In these perceptions, there are so many cases decided on in connection to these constitution checks and balances. You just go through them. Of course, no doubt, it is having the mixed approaches. We have had, directive principle state policies, the federation with a strong centralized tendency. We have an independent judiciary, secular state, single citizenship, fundamental duties, judicial review. All these factors are actually visualizing through the constitution of India. So look at Maneka Gandhi's case, then People's Union for Democratic Rights and Union, then state of Maharashtra versus public concern for governance trust, then Hasinara cartoon versus state of Bihar. All these cases are actually emphasized on the basis of the constitutional goals. No matter when you are dealing with the Constitution of India, we have had our own sources. Kindly have a look on. When we were just framing the Constitution of India through Constituent Assembly debates, of course, we took almost 165 sessions to find out some solutions a country like India. Based on earlier history, the Government of India Act 1858, then the Indian Council Act 1961, 92, then 1892, then 1909, the Government of India Act of 1919 and 1935, then Indian Independence Act 1947. These are the sources of information in connection to the subject matter of the Constitution of India. You should understand the earlier history of mankind. Without understanding earlier history of mankind, whatever you are sharing, few thoughts under the umbrella of the Constitution would be incomplete. Look at the Constituent Assembly debates. We took as many as decision-making process with you to understand what is the Constitution, how exactly Constitution shall be looked upon. See, this case was actually decided by Honorable Supreme Court of India, 13 judges. It was highly expressive to understand the fundamental rights as well. So based on these, the basic structure doctrine was emphasized. Look at the basic structure doctrine, which talks about the supremacy of the Constitution, unity, sovereignty of India, democratic republican forms of government, federal, secular, separation of power, individual freedoms, all are there on the basis of the basic structure of the Constitution of India. This basic structure of Indian Constitution cannot be amended on the basis of Article 368 of the Constitution of India as such. Under Article 368 of the Constitution of India, we have been actually witnessed on the basis of the amendments. See, when you are making some amendments, the basic structure theory shall not be, amended. So on the basis of simple or, special majority as well, as it is highly speculative under Article 368 of the Constitution of India. In a nutshell, I can say that all these basic structure of the Constitution of India shall not be amended. Shall not be amended. They are the basis you have to understand. Look at added to this list of the basic structural features. We have all these like rule of law, rule according to law. Nobody is actually superior or inferior. Nobody is a supreme in eye of law. All are equally footing. This is what Article 14, that should be read out with other parts of the Constitution of India, is well known. This is one thing one must understand. On the other hand, we have emphasized on the basis of judicial review, parliamentary system, rule of equality, harmony and balance between fundamental rights and DSP, directive principles of state policies. It means that part 3rd and part 4th of the Constitution of India, they should go hand in hand. This is what Honorable Supreme Court of India has come across with many things. So that should be read out. All fundamental rights and directive principles of state policies should go hand in hand. So therefore, the harmonious construction theory or classical harmony between these two main streams were actually exposed on the basis of the basic structure theory as such. That has to be looked upon, the basic structure theory as such. So before the pronouncement of the Keshavananda Bharati versus state of Kerala, we had number of instances with you to amend the fundamental rights as well. Take for an example in Shankari Prasad's case, 1951, Sajjan Singh's case, 1965, Golaknath's case, 1967. The ideologies is very different before the pronouncement of a judgment before under the Supreme Court. Take for an example, Keshavananda Bharati versus state of Kerala. Now, you cannot amend the fundamental rights as well, because fundamental rights are the basis. So without which you shall not be called as if a human being, country like India as such. So therefore, you have to understand the classical aspects between the part 3rd and part 4th of the Constitution as well. This case was actually decided by under the Supreme Court in 1973. This was a landmark case in defining the concept of basic structure doctrine as well. The Supreme Court held that although no part of the Constitution, including fundamental rights, was beyond the Parliament's amending power, the basic structure of the Constitution could not be abrogated even by the constitutional amendments as well. So therefore, this is the basis in Indian law in which the judiciary can strike down any amendment passed by the Parliament that is in conflict. This is what the case has outspoken. So in this particular case, the way in which the Supreme Court has acknowledged by saying that you cannot, destroy the Constitution. You have no moral right to destroy the Constitution. You have to understand the Constitution. You have to read the Constitution as. This is what the 13 judges of the Supreme Court came across in this way. Even in otherwise manner, Indira, Nehru, Gandhi versus Raj Narayan, the basic structure theory was upheld in a silver linings in the Mineral Mills case, 1980. The same pretext was actually followed. The Waman Rao case, then Indira Sane versus Union of India. Supreme Court examined the scope and extent of Article 16, Class 4, which provides for the reservation of jobs in favor of backward classes. It upheld the constitutional validity of 27% of reservation for OBC with the creation of condition like criminal exclusion, no reservation in promotion, total reservation quota, should not exceed 50%. This is debatable even today, even in Karnataka as well, by giving 10% reservation for so-called people. Then people are demanding to have more reservations. Let's see, but you cannot go beyond Indira Sane's case. This is underlying principle. However, especially in Tamil Nadu, Rajasthan, Karnataka, we have relaxed and we have crossed more than 50% of reservation in some parts of the country as well. Let's see how exactly this is to be looked upon on the basis of the rule of law, rule according to law. Nobody is actually above the law. Even king also under the law and God. This is what rule of law is emphasized. So based on earlier history, especially in Indira Sane's case, in Indira Sane's case, you cannot go beyond 50% of reservation. However, there are instances where you have crossed the Indira Sane's case as well. That's one of the major aspects. I agree with you. Law is an instrument of social change. It may change from time to time as a science and technological development as well. So law is not static. It is a dynamic one. It is keep changing every day and night. So look at the transformational changes have occurred, especially a country like India, shall also be looked upon once again with a view to understand how people are living here and there. So depending on earlier history, look at S.R. Bommai's case, which was actually decided in 1994. In his judgment, the Supreme Court tried to curb the blatant misuse of Article 356 regarding the imposition of president's rule on states as well. In this case, there was no question of constitutional amendment, but even so, the concept of basic structure was applied. The basic structure theory is to be looked upon from a different perceptions as well. Look at Keshavananda, Vishaka versus State of Rajasthan, 1994. When we were deciding this case, we couldn't find any definition on sexual harassment at working places. Fortunately, when we were deciding this case, India was one of the member countries of CEDA, Convention on Elimination of all forms of discrimination against women, 1979. We, in fact, found to be correct by transforming such kind of international human rights law into the municipal law as well. So therefore, we have defined what is sexual harassment at working places. Look at the Vishaka versus State of Rajasthan's case. In this particular case, we have outspoken on how, in what manner the sexual harassment at working places should be curbed, country like India as well. Look at MC Mehta versus Iran, which talks about public interest litigation for understanding the Article 21 that could be read out with of the Constitution as well, which is actually emphasizing by saying that right to life, which includes right to some environment as well. These are the interesting cases. Please go through it. Of course, our Indian Constitution is actually gambled with many things like military, socialism, democratic setup, dictatorship, communism. All in all, we have. Of course, something has to be looked upon. That things shall also be found to be correct on the basis of Eurocentric, Asia-Afro-centric approaches are concerned. Along with the continuity of these observations, of course, no doubt, Indian Constitution is a borrowed Constitution. Everybody knows. We have borrowed a parliamentary government and rule of law from British Constitution, the fundamental rights and the special position of the judiciary from the United States Constitution, the directive principle of state policies from Ireland Constitution, the federal system from Canadian Constitution, the method of amendment of the Constitution and the method of election of the members of Rajya Sabha from Constitution of South Africa, emergency provisions from Constitution of Germany as well. That's why it is to be called as if borrowed Constitution. The fundamental rights, these are the fundamental rights. You just go through it. I leave them here. You just go through it. And there are some limitations leveled against to doctrine of pleasure, service. You have judicial review. There are some grounds for judicial review. Any illegality, irrationality, procedurality, improportionality, or something else, unreasonable restrictions or issues. So then you can file a case before Honorable Supreme Court of India under Article 32 as under 226. You can move to high courts as well. These are the remedies available. Look at Article 32 of the Constitution, wherein Dr. B.R. Ambedkar, he says that Article 32 that itself is the heart of the Constitution. Without understanding remedies, that you right to remedy, whatever you are sharing on the basis of Constitution would be incomplete. Therefore, right to remedy that itself is a fundamental right that has to be looked upon. Along with the continuity of these, we have had judicial powers under the Constitution of India. Remedies are also available. We just go through habeas corpus, mandamus, co-warrantor, prohibition, certiorari. You can file. Apart from this, there are some challenging issues like implementation, lack of mechanisms we have. judicial activism, institutional building. First of all, let me share with you. You have to read and understand the Constitution of India. Without understanding Constitution of India, whatever you are sharing something about the Constitution will be incomplete. At the end of this session, I can say that this Constitution is actually well known, and it's actually looking as if an elephant's Constitution. Everything is there with you. Only thing is that you have to understand how, in what manner this has to be looked upon. You have to give voice to the voiceless, remedies to the remediless, eyes to the eyesless. Access to justice is one among human rights. In a silver linings, we should give more importance to distributive justice and the corrective of justice as well. We need a comprehensively, relief-oriented and humanistically comprehensive, positive approaches. Without understanding these problems would be incomplete. It means that the fruits of justice should be shared to the people who are left out in the society as well. I mean to say, at the end, that the triple justice, like political justice, economic justice, and social justice should be catered to the people who are left out in the society as well. So with these a few aspects, I take this opportunity to thank each one of you for giving this opportunity to share few views on the Constitution of India in this session. In the next session, I'll be dealing with intellectual property rights, how, in what manner intellectual property rights should be protected and promoted country like India as well. Thank you very much.
Thank you, sir.